Okay, let's start with a simple idea. Imagine you start a domino chain, but at the very end of it, a skyscraper falls down. Now, are you really liable for that skyscraper? I mean, it seems a bit much, right? Well, that's the core problem we're talking about today with remoteness in law. It's all about figuring out where to draw the line on responsibility.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
All right, welcome to the Explainer. If you're prepping for the SQE1, you absolutely have to get your head around causation and remoteness in tort law. So in this explainer, we're going to break down these two really crucial concepts piece by piece. So here's how we're going to tackle this. We'll build it up step by step, pretty much exactly how a court would analyze a case. So to figure out this whole domino effect problem, the law doesn't just ask one simple question. Nope, it actually asks two fundamental questions, and these are going to be our roadmap for this whole explainer. You can think of it like a three-step filter. First, we have to establish a factual link. Did your action actually lead to the harm? Then, step two, we check if that link is legally significant, or if it's just too far-fetched. And finally, step three, we see if anything came along and broke that link. Okay, let's dive into the first hurdle. This is factual causation, and the key tool we use here is something called the but-for test. It's actually a pretty simple, logical question. You just ask, but for what the defendant did, would the claimant still have suffered the harm? If the answer is yes, the harm would have happened anyway, then boom, the claim fails right there. If the answer is no, then we get to move on to the next stage. This famous case, Barnett for Chelsea and Kensington Hospital, illustrates this perfectly. So you've got a man who drinks tea poisoned with arsenic. He goes to the hospital, but a doctor negligently sends him home. Later, the man dies. Now, the doctor was definitely negligent. But the evidence showed the man would have died from that poison anyway, even if he'd gotten the best treatment. So, but for the doctor's negligence, would he still have died? Yes. And that's why the claim failed. All right, so once we've established that factual cause, we move on to the next big question, legal cause. This is also known as remoteness. And this is where the law really starts to set limits on liability. You know, the law on this has actually changed quite a bit over time. The old test from a case called Remoteness was super harsh. It basically said you were on the hook for all direct consequences, no matter how unforeseeable or weird they were. But then came the Wagenmaut, which completely changed the game. It brought in the modern and, frankly, much fairer test of reasonable foreseeability. So here's the crucial thing to get. You only need to foresee the type of harm, not exactly how bad it's going to be or the precise way it happens. For example, if you're driving negligently, it's reasonably foreseeable you might cause some kind of physical injury to someone. You don't have to foresee that they'd break their left arm in 3 specific places. Just physical injury is enough. But of course, it's never that simple, is it? Just when you think you've got the foreseeability rule down, the law throws in a really fascinating exception. Let's get into the thin skull rule.
What this means is that the defendant has to take their victim as they find them. So if a small, foreseeable injury, like a cut, causes a catastrophic result because the victim has a hidden vulnerability, say hemophilia, the defendant is responsible for all of it. You can't just turn around and say, well, I couldn't have known they were that fragile. Too bad. You're liable for the full extent.
And the classic case here is Smith v. Leachbrain & Co. It's a perfect example. An employee got splashed with molten metal on his lip because of his employer's negligence. Now, getting a burn, that's a foreseeable type of injury. But here's the twist. The employee had a pre-existing cancerous condition. The burn triggered the cancer, and sadly, he died. The court said the employer was liable for his death. Why? Because the initial injury, the burn, was foreseeable. That means they were liable for the full, completely unforeseeable extent of that harm. So we've built this chain of causation, but can anything actually break it? Yes, and that brings us to the concept of a new intervening act, or if you want the fancy Latin, novus actus interveniens. This is basically an event that's so new and so significant that it just completely snaps the chain of causation.
It comes along after the defendant's initial negligence and becomes the real cause of the final damage, letting the original defendant off the hook for anything that happens after.
And there are generally 3 ways this can happen. It could be an act of the claimants, an act of a third party, or a totally unforeseeable natural event.
Let's talk about the claimant's own actions first. In McHugh v. Holland, a claimant had an injured leg due to his employer's negligence. But then, he tried to go down a really steep staircase with no handrail, which is not a great idea. His leg gave way, and he jumped to save himself, but ended up breaking his ankle. The court said, look, that was your own unreasonable act. That act broke the chain, so the employer wasn't liable for the broken ankle.
Now, here's a big one for your exams: medical treatment. Let's say your negligence injures someone, and they get medical treatment that's also negligent. Does that break the chain? Usually, no, because needing medical help is a foreseeable consequence of getting hurt. The original defendant is still on the hook unless the medical treatment is so incredibly bad that it's fair to say it's a whole new cause of the damage. The bar for this is pretty high.
Okay, we've covered a lot of ground. We've got the but-for test, remoteness, the thin skull rule, and broken chains. So let's put it all into practice and test your knowledge with a couple of questions.
Okay, read the question carefully. Think about the principles we've just been discussing. What do you think? What's the right answer here?
The answer is yes, and this is a classic application of the eggshell skull rule. It was reasonably foreseeable that a car crash could cause some type of personal injury, right? Maybe whiplash or shock. Because that type of harm was foreseeable, the defendant has to take his victim as he finds him, even with a super rare unknown heart condition. So he is liable for the full extent of the harm, including the completely unforeseeable death.
So here's your final revision checklist. Just remember the sequence for any problem question. Start with but for. Then check remoteness using the wagon mount. Always remember the thin skull rule. And finally, ask yourself if anything has happened to break the chain. Follow those steps and you'll be on the right track.
And I want to leave you with this final thought. At the end of the day, all these rules, they aren't just abstract legal logic. They're tools that the courts use to try and get to a fair and just result. So as you're studying, don't just memorize the cases. Try to understand the why behind the rules. That, right there, is the real key to mastering this for your exam.